Hello everyone and welcome to an introduction to Contempt of Court for PI lawyers. This was going to be a double header talk between myself and Andrew McLaughlin, who's going to be talking to you about fundamental dishonesty and Section 57. Andrew can't join us today, but in an era where everyone's baking and watching Bake Off and Delia and Nigella and all the rest of it, here's one I made earlier that you can find in the live event Q&A. What will be published is a link to my previous talk on fundamental dishonesty at Section 57 and Quox, and you can watch that in your own time later. It is useful to watch because the two dovetail together, and one of the things that I was saying back in, I think it was April earlier this year, was that there had already been some changes to the landscape, which was specifically to do with witness statements and expectations in terms of witness statements, and that was going to have an impact on FD. Now in this talk, in terms of committal contempt, we're going to learn a bit more about that, and the fact that there have been even bigger changes that have happened in the interim. My slide deck is a little laggy, so apologies if it's not catching up with what I'm saying, but I'm going to crack on regardless. In terms of this subject, as I say, it is now become front and centre given recent CPR changes. When I agreed to do this talk, I was just going into paternity leave in April. And I thought, right, it's great. I know all of the case law, that there's a great deal of information that's around this topic, and the case law that you need to navigate. What's happened since then is that in May of this year, a consultation was put out in relation to reforming Section 81 in terms of committal for contempt, and ultimately that was implemented and has come into force in October. So we're really at the cutting edge in terms of what the court, the senior courts and the Civil Justice Committee expect to see developments in terms of litigation. The value of contempt and knowing about committal for contempt for PI lawyers: if you're a claimant solicitor, you're going to know the basics. If your client ultimately faces the worst situation, which is a finding of fundamental dishonesty because of recent CPR changes, it's very likely, or it's a lot more likely than 6 months ago, that they could be facing an application for committal for contempt. As a defendant's lawyer, it's going to be essential, because certainly large defendants now, and those defendants who are very prone to or subject to fraudulent cases, are going to just expect you to know about it. So hopefully you will find this talk useful. This is being recorded, and so if your colleagues want to obtain the link, the link will be sent to you. There will also be some Word document notes that will also be sent out to you, so you'll have a standalone document in addition to the slides that I'm showing you, to help you, that can sit on your desk if you print it out, and will be of assistance. And this is the advertising part, is to say that there are not many barristers in the Southwest who deal with FD and committal for contempt. There are a few of us. I'm one of them. But it's certainly useful when you have a case where you have a real suspicion that this isn't just a marginal fundamental dishonesty case, but a case which goes a lot further than that, and that there are active elements of fraud. It's certainly worth getting counsel on board early, because they are linked but parallel processes in terms of FD and committal for contempt, and it's something to bear in mind, and good that we can offer you a joined up service. What is contempt of court? Well, we're concerned today not with the whole sweep of contempt, which is a very large subject, but it's contempt in terms of making false statements on affidavits, affirmations, or any document that requires a statement of truth. The power and the nature of a committal for contempt is found in the revised Rule 81.9. which says, quote, if the court finds the defendant is in contempt of court, the court may impose a period of imprisonment, an order of committal, a fine or confiscation, or other punishments under the law, which is typically ultimately a suspended sentence. As I've already alluded to, and you will have already encountered in the course of litigation this year, the 6th of April 2020, the CPR is amended to provide a requirement for express and specific language to be included in witness statements and court documents. On the screen in front of you is the express language that you must now be copying and pasting into your witness statements and documents. And of course, there is a linked duty on you as the practitioners to explain to your client what this means if you're making a false statement, and ultimately what the consequences are if you're found to be in contempt of court. This was the first signal this year that the court was getting serious, really serious on FD, and it's certainly too soon to say that there's been one of these cases yet. Certainly my colleagues who've not been on paternity leave haven't seen a committal for contempt hearing yet, nor would you expect that given the length and the sort of gestational period of litigation, but we're going to see them in the next year or so, or 2 years, we would expect to see the first applications. As a result of the court recognising that it was going to make expressly clear that that a false statement could result in a committal for contempt, the court has gone further. The senior courts and the White Book Committee, Civil Justice Committee, have gone further, and they've, as I've said, amended Rule 81 of the CPR. Previously, in order to really understand even the basic procedure for making an application for permission and committal for contempt, you had to look at a huge tranche of case law and all of the litigation that had been generated as a result of the old legislation and the old CPR, and bluntly, it was a real chore. It was like wading through treacle. There are also different processes and procedures in place. What we now have under Rule 81.3 is a single procedure for contempt applications, and effectively the whole process has been codified. So your go-to destination, if you want to know more, other than picking up the phone or emailing me and my colleagues, is actually looking at 81. As you would expect with a new amendment, the guidance is relatively slim, and the commentary in the White Book is relatively slim, or will be slim at the moment. Of course, one assumes that there is a White Book update on this in the offing, but it will be coming to our chambers and our offices, which we're all locked down, so we're not going to see it for a while yet. But the guidance, I'm told from those who are involved, is relatively slim because they think 81 does what it says on the tin. There are now only 2 circumstances where you need permission to make a committal for contempt application. And let me explain what that process is. Because this is a process where the civil courts are exercising their ultimate power, which is the possibility of sending someone to prison, there are a great number of safeguards. There will be prescribed language warning people what they can expect, what their rights are. But the first safeguard is a court actually ultimately granting permission or not to defendants in circumstances in order to make their committal application. You can fall at the first hurdle, and I will talk you through that test in due course. But the first thing to say is that for the purposes of today, and what concerns us, which is false statement contempt, false signature affidavits and affirmation contempt, you must seek permission to make an application. In terms of other features that are new or codified in 81. There's now a standalone procedure where the court commences contempt proceedings on its own. That is an important point to know about, because it may well be that you don't make an express application for permission, but the court may well impose it in any event. For some reason, the notes have gone in the wrong direction. Apologies for a second. Apologies for this, ladies and gents. What I produced for you in this document and the next few slides and in the notes is the checklist that I would apply if I was ever advising in one of these cases, and if I was preparing one of these cases. Item number 1 is that you must seek permission for committal for contempt in false or dishonest statement cases. The permission stage and the issues that you're speaking to in your committal application, although it's a safeguard, it isn't as stringent a safeguard and as weighty a test as the actual substantive committal hearing itself. The committal hearing itself, the burden of proof, is beyond reasonable doubt. At the permission application, the court is asking itself, is there a strong prima facie case to grant permission and pursue a committal for contempt? Is it in the public interest? That's a relatively low threshold where there's been a finding, ultimately a fundamental dishonesty or a Section 57 dismissal, and then the action is in furtherance of the overriding objective. So ultimately you'll be, if you find yourself or counsel is addressing the court on those issues, those are the 3 main tests that they will be speaking to. The routes that you go to, or rather the court that you're having to apply to, again, is set out in CPR 81.3. So if you've got existing High Court or County Court proceedings, you make your application by way of Part 23 in those proceedings. That is important to note, because there is a different procedure that's set out where you ultimately have a case that's been withdrawn, or ultimately a case where there's been a finding of fundamental dishonesty and it's been dismissed. It's easy to get it wrong, and therefore again look to 81.3. I won't go through all of those different processes, but they are there, they're clear, and your direction of travel is set out for you. In terms of service, again, because it's such a strong power that the court's using, it can only be by personal service unless the client is still represented. Now, this is an important point for claimants and defendant solicitors, because if you're a claimant solicitor and your client is found to be fundamentally dishonest, you know you're not going to be getting any other money out of this case. Typically one will want to escape the situation as much as possible, and ultimately if you're a defendant, there's always the danger of the person who's been found to be fundamentally dishonest going to ground or disappearing. So ideally you would like to serve on the solicitors. 81.5 says personal service, but if there are solicitors on board, 81.52 allows you to serve on them, but they are entitled to object within 7 days. If they miss that opportunity to object in 7 days of receipt, then that is good service, effectively. A word on language, because it's a curious one. Normally the old language used to be applicant and respondent, as with old applications. Here the new language describes the person applying for a committal for contempt as the claimant, and the person who is receiving the application for committal for contempt as the defendant. So it's a reverse of their descriptions in the substantive hearing. I flag that up because it's easy to get confused by. Within the application that you're making, there has always been a certain amount of mandatory language, and there, no doubt, those of you who've dealt with this before, deal with FD, or alternatively have saved council's previous draft copies of contempt applications. Need to know that your pro formas are probably now almost certainly out of date. There is language that's been added in that wasn't there previously. So again, if you're doing this yourself, if you're making your applications yourself, you will need to check 81 with a fine-tooth comb, or if you've had counsel involved in the FD hearing, get them to draft the application for permission and the application for committal, so that they effectively are on risk, but they're doing it right. Because this is a sort of quasi-criminal situation, if you omit language, if there are certain things that are set out in 81 that are mandatory and you don't do, you run a very serious risk of getting your application struck out. And so this is not like a normal civil pleadings where you get to remedy it later. There, in terms of your objective of getting a committal, if you're not getting it right from the outset in this mandatory language, then you've possibly got very serious difficulty ahead. This is a summary of the mandatory language, so I've not copied and pasted the mandatory language for you because we would be going through reams and reams of information, so don't rely on this document as something that you can copy and paste into your application. It goes without saying, you have to set out the nature of the contempt, explain to the defendant what it is they're said to have done, a brief summary of the facts that amount to their contempt set out chronologically. You must tell them that they have a right to be legally represented. You must tell them that they're entitled to reasonable opportunity to obtain legal representation. You must tell them that they're entitled to legal aid, and it won't necessarily be means tested in the circumstances. You must tell them that they may be entitled to an interpreter. You don't have to say if English is not your first language, but you simply have to tell them you may be entitled to an interpreter. You must tell them that they're entitled to reasonable time to prepare. You must tell them that they're entitled to but not obliged to give written and oral evidence. You must tell them in your application they have the right to remain silent and the right to decline questions that may incriminate them. You must tell them the court will proceed in their absence if they don't attend, and you must tell them the standard of proof is beyond reasonable doubt. You also have to tell them that the court may imprison, fine or confiscate their assets, and you must tell them that if they admit their contempt, particularly if they admit it early and wish to apologise, this could have an impact, a significant impact on their punishment. Ultimately, you also have to tell them that the court's findings will be provided in writing as soon as practicable, and the court will sit in public unless they or their solicitors make applications on their behalf. The presumption is very much in favour of public sitting. Attached to your application, there are certain documents which you have to have, and there are certain documents which I would advise you to include. You must have an affidavit or an affirmation attached to your application, setting out in detail the nature of the contempt and all of the other things that we've summarised previously. In an ideal world, you'll want that to be from either the solicitor with the conduct of the matters. So if you are the defendant solicitor making this application, and I mean defendant in the substantive matter, claimant solicitor for the application, the norm ought to be that you are the person who's making the statement, unless there is for example, for a local authority, an insurance agent, or there's a managing partner of a company who's been involved throughout, who wants to put their name to it. It's easier, bluntly, if it's the solicitor, but you will be attending. It's not the kind of thing that your witness state, your affidavit or affirmation will be taken as read. It's definitely not going to be. You must include a list and the documents themselves that are signed by a statement of truth, which you assert are signed without a reasonable belief in the honesty of those documents. It's important that you have both the summary so that the judge has an easy go-to document and the actual documents themselves. It's not enough to simply refer to them. They need, the document itself needs to be proven, so the judge has to see it. It's not mandatory, but it's absolutely advised that you then have any other document which effectively paints the broader picture that evidences the dishonesty. So, for example, if you've got medical records which show that the claimant has said she broke her leg on X day, her left leg on X day, and you've got a GP's document entry that says it was broken, the right leg was broken on Y day, and it was because she was drunk or something like that, you need that document, and you need each document which evidence dishonesty. If there are any judgments where fundamental dishonesty is found, or a Section 57 dismissal because of exaggeration, you need a copy of that. You will need the full transcript. It's not enough to simply refer to the hearing and the outcome. You need a transcript of the judgment itself. From your perspective as the claimant solicitor in this matter, you will really want to probably get a transcript of the cross-examination as well if the dishonesty emerges within that process. Alternatively, if they've made any written admissions, either in withdrawing their case or when after an FD finding or Section 57 dismissal, and you've ultimately said, by the way, we're going to make an application for committal for contempt, if there's any written correspondence where there's anything even hinting at an admission, you're going to want to attach that too. In terms of the contents of the affidavit and affirmation, again, this is your opportunity to effectively go over what the application must touch on in much greater detail. So it goes without saying you need to set out the nature of the contempt in much greater detail. A comprehensive chronology, and I always think that this is, if you're the solicitor making a statement, it needs to almost be paragraph 2 of your statement, setting out each instance of contempt, and so that you can refer to it on a paginated basis. That is definitely mandatory. It's also important where you've ultimately, in a PI case, got someone who's effectively attempting to defraud the claimant in the application. It's very important that you set out the value. What is the cost of the fraud itself? Not the costs of the litigation as a whole, but expressly what is, whether it's that there's no personal injury and so you're saying it's the entire value of the case, or whether if there's a Section 57 dismissal, ultimately the difference between for example, loss of earnings versus the fraudulent loss of earnings. What is the value? Then something that's not required by the rules, but I always advise clients to do in these cases, is a statement of the notional cost to the defendant, the claimant in the application, of this litigation. Now, when I say notional costs, I don't mean the solicitor's costs, because if you've had a Section 57 dismissal, an FD finding, there's a good chance that your judge will have ultimately given you costs on the basis of that finding. But what I mean is the cost to the organisation itself, and this is where getting your lay witnesses on board it is really important. How many hours have they spent, do they think, on average? How long has it taken them to ultimately address this fraud? The things that ultimately a costs order in the civil litigation just won't ever reflect. That is important, and that is valuable. It's also important to set out who meets that notional cost. If it's the public purse, if you're representing the NHS, if you're representing a government department or a local authority, absolutely essential to make that clear. And it's also very important to highlight within that affidavit or affirmation how the dishonesty came to light. If it comes to light in the middle of your investigation and the claimant, your case investigation, the claimant, the defendant in the application is resisted throughout, that's going to be highly relevant. If there's a very early admission on their part and an attempt to withdraw their case, that's also going to be relevant, but ultimately help the defendant in that matter. So very important to highlight that, and that dovetails with the last bullet point there, which is that ultimately highlighting when admission takes place, did they fight and push their dishonesty right the way up to court? That's going to be a relevant consideration. I won't talk you through the court-initiated procedure, but it is very important that you're alive to it. It's found in Rule 81.6. If there's even the suggestion of dishonesty and dishonesty on a scale that you think in the very outset, even the very outer ranges of this litigation might lead a court to consider committal for contempt, it's important that you consider it, and it's important that you speak to your barrister who's dealing with the ultimate FD case. Why? Because the court could say, well, Mr. X, Mrs. Y, we don't care that you don't want to apply for a committal for contempt. I, the judge, am taking that forward, and the judge is perfectly entitled to ask for reasonable assistance there. So you may well be spending, or your firm may well be spending money where there isn't a professional desire to do it, but the court is asking you to, and you have to assist in those circumstances. I've broadly summarised what is being considered in a permission application. I don't propose to go over that. What I will say is that the permission application is now folded in to the broader committal application. So before, what used to happen is that there would be a standalone document where you seek permission and a witness statement that went with that, and that would be one document. And then if you were successful, if you got your permission, there would be the second application, the committal application, and an affidavit that would be attached to that. That's not the case now. It's all put together, and so in your witness statements and ultimately in the documentation itself, the application itself, and for counsel's purposes for their skeleton argument, they're dealing with it all in one go. That said, this isn't going to be a rolled up hearing. It's not like an appeal where you'll get a permission hearing and the substantive appeal, and a judge could say, right, we'll roll them up together. Why? Because the defendant is entitled to seek further advice, that there are all these safeguards in place in terms of proper preparation. So it's very unlikely a judge is going to roll those up together. In terms of a few points, and we've got 10 minutes left, so I'm going to move through at a gallop here. What I've put in my notes and the slides that are in front of you are the cases that aren't affected by the changes to Rule 81. They're the old authorities, but they're relevant considerations for the substantive committal hearing itself. If you are the claimant and asking for a committal for contempt, your objective is always going to be imprisonment, that you want the person who has lied and conducted themselves dishonestly sent to prison for a period of time. I think it's probably worth emphasising that, because I think that it's whilst insurers and defendants, solicitors aren't seen as particularly squeamish individuals, I think you have to recognise that ultimately the end of this process, if you're taking it forward, is someone going to prison for a period of time. and you have to be prepared to pursue that to the end. And if there's any squeamishness on the part of the insurer or your lay client, you need to be clear about that if you're embarking upon that process. And it's surprising actually that there are some instances that I've had, and I know colleagues have had, where ultimately the lay clients wanted to pull the plug even though they've been defrauded for a not insubstantial sum of money. What the court says is that ultimately the High Court has approved a hearing just a few months ahead in terms of the correct approach to contempt. Paragraph 5 of South Wales Fire and Rescue Services in Smith, a case which is otherwise quite useful for people defending committal for contempt applications. Those who make false claims, if caught, should expect to go to prison. There's no way to underline the gravity of the conduct. There is no other way to deter those who may be tempted to make such claims, and there is no other way to improve the administration of justice. The public and advisors must be aware that however easy it is to make false claims, either in relation to liability or in relation to compensation, if found out, the consequences for those tempted to do so will be disastrous. They will almost inevitably lead, almost inevitably in the future going to lead to sentences of imprisonment, which will have a knock-on effect, and ultimately your life is likely to be ruined. This is, as I say, an area of law which is not for the faint-hearted, and sometimes doesn't sit very easily for civil lawyers, full stop. The point was again repeated because it was again a point of debate in Holmes for Haringey and Farry in 2013, where again it says false and lying claims undermine the administration of justice in a number of serious ways. Insurers have to spend a great deal of time and money identifying and weeding out claims they think may be fraudulent. False claims damage our whole system in this country, and the system of adversarial justice, depending as it does on openness, transparency and honesty. False claims can take up a great deal of court time and precious resources, as Judge Mitchell explained when he struck out your claim. Ultimately, again, reiterating that this is as serious as it gets, and when one reads that judgment, partnered with the new guidance on witness statements and particulars of claim, it hammers it home. In terms of typical points that will come up in these hearings, in terms of mitigation, once you've reached the stage of a committal hearing, and I take a step back before I take you through these cases, a defendant to a committal hearing, and you've already heard, is well advised that if they are bluntly banged to rights, that if they have effectively been found out to be dishonest, they are well advised to admit their dishonesty at the very start of that process, and ideally even before that process began. It's very rare that in a permission hearing and a committal hearing, people are ultimately, certainly at the committal stage, contesting their dishonesty, because ultimately those making the applications will probably have a court judgment unless the matter has been effectively withdrawn. And these days we simply reinstate withdrawn mitigation if we've got a strong suspicion of fundamental dishonesty or exaggeration, and so you will already have your civil finding. The burden of proof is different, and those who wish to resist have the right to, but it's once in a blue moon that those sort of cases come up, and so matters shift effectively to mitigation. That you, as the defendant solicitor, are effectively trying to ensure that your client doesn't have a custodial sentence. You, as the claimant solicitor, are looking for, at a bare minimum, a suspended sentence of imprisonment and imprisonment, and ultimately so that you can get the matter reported in the local press and you let people know that you're dealing with fraud in a serious way. One of the frequent points that's raised in mitigation, and it will be something that's familiar to people who started out in crime or deal with crime generally, are compassionate arguments, and one of the frequent points that come up is I'm the primary carer for my child, and all of this uncertainty in terms of the weight of litigation has caused worry for me and my family. Lane and Shah 2011, the court says very clearly this was a case where there was financial dependence, albeit the child was at university, that wasn't sufficient, that the passage of time where this was hanging over them wasn't sufficient to downgrade the sentence of imprisonment, that the fact that there would be disastrous consequences to the family income wasn't sufficient to downgrade to a suspended sentence, and in that case ultimately a 6-month sentence of imprisonment was given. Those of you who have a vague recollection of your crime from way back when will know that it's likely that she will have only served half of that, 3 months. In Holmes, Haringey, for Haringey and Farry, there was actually a lot more than that. There were quite young children involved, and the children themselves were actually very young. So Haringey was both the claimant asking for a committal, but also providing children's services report, talking about the vulnerable children, and there were Article 8 arguments in terms of the Human Rights Act. Again, there the court said that was insufficient to mitigate a custodial sentence, that there was a husband involved in those circumstances and he could fulfil the role of primary carer whilst the defendant effectively served her sentence. Ill health is another classic example, as is age, as is substantial, as I've touched on, disruption to the household income. Havering and Bauer, there the claimant had the defendant had long-standing ill health. They would certainly lose their job because their job was about honesty anyway, but you get imprisoned. I put my employment law hat on and say bluntly, you're going to lose your job. You can't turn up to work and fulfill your obligations. And they were likely to lose their family home. That was not sufficient to avoid a custodial sentence in that matter. Haringey and Farry, again, the claimant turning, the defendant turning 60 and being frail, wasn't sufficient mitigation. One of the curious things that has come up again and again since the rules of FD came in, and Section 57 and the rules about quoks is defendants, solicitors or counsel saying, well, look, this person has lost their, they've lost their litigation as a whole. If they had a personal injury but they've exaggerated and there's been a Section 57 dismissal, they've lost the thousands of pounds or tens of thousands of pounds that they ultimately would have been entitled to, and they have a costs order against them. That's punishment enough. And the situation was unclear until the case of EUI and Olyanka, albeit we all had a fairly firm view that wasn't sufficient in terms of mitigation. And the court made clear, again, the existence of the civil action cost liability doesn't matter, the reputational damage doesn't matter, the impact on the children was insufficient. In that case, the only mitigation was that there was an early admission, and therefore they applied a 25% discount in terms of their custodial sentence. Section 57 is not punitive. The rules on fundamental dishonesty are not punitive. There is a public policy reason why the court is entitled to do those things. The costs order is not punitive. It is not mitigation, and it doesn't purge your contempt. And from a claimant solicitor's perspective and the claimant's the claimant's perspective overall, you will say, if you have a costs order, we will set up a payment plan. We won't collect, or we can't collect, the debt whilst this person is in prison. but we will suspend their costs payments for the period that they're inside, and we will give them X period for them to come out and find gainful employment, and then there will be a payment plan in place or an attachment to earnings order. As I say, this is a rough area of law, and you don't embark on it lightly. The sentence, the maximum sentence for contempt of court is 2 years, and the maximum amount of time the court can suspend that sentence, if it's ultimately saying it wants a suspended sentence, is 2 years as well. So if you committed any other criminal act in those circumstances, if you had a suspended sentence, you're likely to be inside. One of the things that I've skimmed over very quickly, and it's probably worth raising here, is that often the contempt of court is partnered alongside defrauding other things that are discovered in the process. So, for example, I had a case for a South West local authority just before paternity leave, where the fraudulent claim for loss of earnings was discovered because there was a fraudulent claim for housing benefit to the same local authority, and ultimately the fact that these are parallel frauds, as it were, albeit they're discovered in the investigation, that can be seen as an aggravating factor. If in the course of investigation there's reference, for example, to the Inland Revenue, because people who defraud local authorities and people who defraud their employers, or people that they say are negligent, are possibly going to defraud the taxman as well, then there's the possibility if that's discovered that their suspended sentence effectively is set aside. It comes into operation and they have ultimately extended. So I'm mindful that's a gallop. I'm mindful that we didn't have that long time in a brand new area of law. And I'm mindful that I've simplified some very complicated concepts. There is a Q&A panel, which if you move your cursor down to a bar towards the bottom of the screen, you can open. It's one of the entries, and you can ask questions there. If you don't want to ask questions today, you are perfectly free to email me, and I will do my best to get back to you. So before I go on, are there any questions about this topic? I don't think there are. I'm just going to ask our marketing people who are IT wizards. No, everyone's shaking their head. That either means I went too fast, it's too confusing, or you just think, oh God, I need to read the notes before I ask any questions. So I'm not sure what which of those outcomes is the right one. But if you have any questions before I wrap up, do feel free to put them in the live event Q&A question section, or email me and I will do my best to give you an answer. The last thing to say is that there will be a feedback form either posted in the live event Q&A, or you'll get it emailed to you if you've signed up today. Please fill that in. My normal joke is that if I don't remember to tell you that, the clerk send me to court in Carlisle, but at the moment I'd actually quite like to leave home and go to court, but still do fill that document in, because it helps us improve what we're doing in terms of delivering talks. I think the last thing to say is that this is a talk that is probably going to be worth revisiting in about 6 months to a year's time, because I do anticipate that for the worst instances we're going to see a spike of these cases. And if you have any suspicion, even if you're early doors in a fundamental dishonesty style case, do drop me a line. They are interesting cases, and I'm happy to help. Thanks very much for your time.